is chapter 23 that we're going to be talking about, and this one will be on Canvas on the 13th of April. This chapter is about the title and risk of loss. What we're talking about in this chapter is the goods that we talked about in a couple of chapters back. When do you own them? When does the title pass from the seller to the buyer? It also talks in this chapter about when is it the buyer's responsibility, when it is their liability if the goods are damaged or destroyed, and when is it still staying with the seller. And these three things become very important because, first of all, if the goods are damaged, insurance pays off when there's liability on your part. So you have to, first of all, find who is liable, who is responsible for this loss. It's also very important to creditors, because a creditor, if they have a judgment against someone, they can only take goods that belong to that person. And if they are trying to collect a judgment against a seller, and the goods that the seller is selling, title has already passed to the buyer, and they take those goods, then they could very possibly be liable for conversion, which in a lot of places amounts to 3 times the regular damages. Again, a municipality maybe who's trying to collect on taxes, back taxes that are owed, can only take them from goods that, let's say that the buyer owed taxes that were unpaid, and they're coming to collect the taxes, and they're taking goods that they think belong to the buyer, but the buyer doesn't have title yet. That's a real problem for someone trying to do that collection. They can't do that. And we need to know when you get this insurable interest. Insurance is not the answer to everything. First of all, you have to have an insurable interest in order to buy insurance. And an insurable interest means that the destruction, the theft, the damage, whatever to these goods is going to cause a financial loss to you. If that's not going to happen, then maybe you don't have an insurable interest. And an insurable interest, you know, can't buy insurance. Okay, so those are really the 3 key things about why we have to know about when title passes and when the risk of loss passes. The first step in this is to identify the goods. And normally when I'm teaching this in class, I actually do it with goods so that you can really see what's going on here. I also try to have people use the chart in the book. In my book, it's on page 444, talks about when title passes. If you can understand that chart, you're going to be able to understand what's going on in this chapter. And I'll tell you that there'll be a couple of questions on the last test coming from this chapter. If you can read those charts, it'll be a lot easier for you to answer those questions. All right, so the first step is that the goods must be identified. Okay, and identified means we need to know, if this is the contract, which goods go with that contract. That's what we're trying to figure out. And for this, there are 3 different kinds of goods. We have existing goods, future goods, and fungible goods. We talked about existing and future goods before. I told you it would come up again. Existing goods are goods that are physically in existence and they're owned by the seller. Future goods are goods that are either not yet made, not yet manufactured, or they're not yet owned by the seller. Fungible goods, third kind of goods, are goods that when they're mixed together, you can't tell them apart. Such as if you were a soybean farmer and you take them to a co-op silo and everybody's is put in the same place, they're all mixed together and you can't separate all of them out. Milk, if milk is being picked up at a number of farms going into the one truck, when the milk is all put together, we know how much milk each farmer put into that truck maybe, but it's fungible, it's all together now. All right, so Those are the kinds of goods that we are talking about. So when are they identified to the contract? If they are existing goods, they're identified to the contract when they're selected for that contract. So if you go into a store, you pick a particular item up off the shelf, that's what you're going to buy, it's identified to the contract. Now we know what it is you're buying. If it's future goods, well, they kind of have to wait until they're made, but future goods are identified when they are shipped, they're marked, or in some other way identified to the contract. We could put our yellow ribbon around a bunch of crates and go, okay, those are going to this contract. Now they're identified. It can be any way, but somehow you have to know those goods are going to this contract. And fungible goods, it's the same thing, when they're shipped, marked, or otherwise designated. The effect of identification is that now the buyer has an insurable interest. There is a possibility that they would be liable, and that if they were found to be liable, that they would have a financial loss or suffer a financial loss. Okay, so first you identify the goods. That's one of the most important steps. If the goods are not identified, title does not pass. Just remember that. If you have goods that are not identified, title doesn't pass. Okay, so let's assume now that the goods are identified. Now we want to know, when does title pass? The first group we're going to talk about is when there's a document of title. If there is a document of title, then title passes when the document transfers. Now, many states have their own rules about such things like cars, boats, and that could be separate rules from what we're talking about here. What we're talking about here primarily are bills of lading and warehouse receipts, which we mentioned a couple of chapters ago. Okay, it's governed by Article 7 of the Uniform Commercial Code. Article 7 is one of the most recent parts of the code, and it takes into account the fact that most warehouse receipts and bills of lading now are electronic, and it allows for an electronic transfer of these kinds of documents. So at that point, the title will pass when the document transfers, whether it's an actual physical transfer of paper documents or whether it's an electronic transfer. Okay? Now, in the types of contracts that we're talking about under Article 2, UCC, there is nothing in there that says that a seller has to deliver goods to the buyer. Nothing says that. Now, that doesn't mean that you can't put into your contract clauses about how goods should be delivered to the seller, how they're going to get to the buyer, how they're going to get from the seller to the buyer. You can do that. You can put that in your contract. But if there's nothing in the contract, well, we still have rules about what's going to go on. Okay, so let's assume right now that we have what's called a non-shipment contract. Nothing in the contract about when the goods are going to be shipped. Okay, nothing is there. All right, if we have a non-shipment contract, then we want to find out what's the place of delivery, first of all. It is the seller's place of business, or if they're not a merchant seller, then it's the seller's residence. Remember, the Uniform Commercial Code covers both merchants and non-merchants. The rules are frequently a little bit different. So in this case, under a non-shipment contract, the obligation of the seller is delivery, and delivery is at the seller's place of business, or at the resident if they're not a merchant seller. Okay? Now, if you don't have documents of title here, we're not talking about that, and there's nothing in the contract about shipment, then title will pass when the contract is entered into. If there's no document of title and the goods have been identified. Remember, that's first step for everything, is the goods have to be identified. So, the non-shipment contract, goods are identified, title passes to the buyer, ownership passes to the buyer when the contract is entered into between the buyer and the seller. Okay. If we're talking about warehouse arrangements, and again, remember back, we did the chapter before that talked about warehouse arrangements. So if there's a warehouse arrangement, title passes when the contract is entered into. Okay? Excuse me, when the buyer gets the paperwork. That was wrong, forget that. Okay? Title passes here when the buyer gets the paperwork. All right? So when the document is transferred, when the buyer receives the document of title, or the goods pass from the seller to the buyer, the title will pass. All right. Sometimes title, I want to go back and do that one, passage of title and warehouse arrangements, because I want to make sure that I didn't mess that one up. So let me do that one more time. If the goods are in a warehouse arrangement, they're in possession of a third party, title to the goods pass from the seller to the buyer when the buyer gets the documents of title. If there's no document of title, for some reason or other there's no document of title that was required, then the warehouse will turn over the goods and they're available for the buyer to take. Then whatever paperwork it is you needed to get those goods, when that's transferred, title will transfer. Okay, so let's talk about a couple of the other ones here where title may not pass. In stolen goods, title does not pass through a thief. Okay? Even if it is someone down the line who has no idea that the goods were stolen, title does not pass through a thief. And no matter how far down the line you might be, assuming we can prove all of this, no matter how far down the line that you may be, if you buy goods that were stolen, they belong to their rightful owner, not you. Okay. Now, there's this thing called estoppel, and estoppel here means prevented. It's a term that gets used in the law time, but it means you're estopped. You're not allowed to. You're prevented from doing something. And in this case, it's when the owner has acted in some way that's misleading. And then the owner can't come back and say, oh, I really own those goods. For example, if you have a car and where you live, the insurance is really, really high. So you put it in somebody else's name at their house so you don't have to pay so much insurance. And then, so for some reason or other, you have to prove that that's your car. Well, you're stopped from doing that. You're prevented from doing that. So it's the other person's car. They have title. You are trying to commit a fraud, actually. So you are not going to gain from that. If you put it in somebody else's name with an attempt to mislead others, in this case, to attempt to defraud your insurance company, you're not going to be able to come back later and go, oh, really, that's mine. Okay? Sometimes there is authorization given to pass title. If there is, for example, a mechanic's lien. If there's a mechanic's lien where you take your car in for repair and then you don't pay the repair bill, so the person who fixed the car has a lien on it for the repairs and maybe storage because you didn't come and pick it up either, then they are allowed to, if they follow the proper procedures, whatever state you're in, whatever laws they have to follow, they follow the proper procedures, they're going to be able to pass title to that car. All right? Sometimes there is a voidable title. For example, if someone got goods by fraud, then, so that title would be voidable, the whole sale would be voidable. If it's sold to a good faith purchaser before the seller has moved to set aside that contract, or the buyer, whoever it was that was defrauded, they haven't moved to rescind that contract, and a good faith purchaser gets the goods, then they get a valid title. Part of this is, that it would just be impossible if no one had moved to set it aside for someone to know that it was a bad sale. Okay, and then a bailment. Now, again, we talked about bailments in one of the other chapters, and I do want you to kind of know as we go through these that um, the chapters build on each other. They're not all separate little things. That something that we talked about 2 chapters ago still applies now that we're 2 chapters later. So we've talked about bailments, and if you recall, a bailment is when you give someone your possession of your goods, but you expect to be able to go back and get them at some later point in time. It's not, you are not transferring title. However, there are some occasions, so if you're giving someone possession of your goods, you better be very careful about what business you're giving to. That where someone who is a bailee, the one who gets possession, can transfer good title to a buyer who knows nothing about this. If you have a good faith purchaser. Now in this case, it would have to be a bailee who is in the business of selling that particular kind of good. The buyer who comes in to get it has no way of knowing that this is a bailment, that it is not, it's not really for sale, it shouldn't really be for sale. And they don't know that. They're an innocent, good faith purchaser, and they come in and buy the item, then they get title. And your remedy, if you're the person who gave up possession, would be to sue the person that you gave up possession to. For example, if you took a piece of jewelry in for cleaning or repair, and you get into a jeweler who was in the business of selling jewelry, and somehow, we'll say innocently, but somehow that item that you took in for cleaning gets mixed in with the items that that jeweler has for sale, and a customer comes in and buys that item. That customer, assuming they knew nothing about the fact that you brought it in for cleaning, will have title to those goods. Your only remedy then will be to go after the jeweler. Okay, so let's move then to some contracts that are not non-shipment contracts, but are actually shipment contracts. Okay, and we have some delivery and shipment terms. There's a couple of extra ones in the book here. You can read through those and look at them, but the ones we're really going to be talking about are FOB, free on board, which is place of shipment, and FOB, place of destination. Okay? All right, remember, UCC does not require anything in the contract about shipment. So when we're talking about this, from now until the end of this section on passage of title, there's something in the contract about shipment. You have negotiated, the seller and the buyer, about how the goods are going to get from the seller to the buyer. All right, so the first one, place of shipment. The obligation of the seller in a shipment contract is to get the goods to the carrier. Let me refer you back again to the chapter that we did that talks about carriers, our common carriers, contract carriers, private carriers. Okay, the obligation of the seller is to get those goods to the carrier. If it is a destination contract, then the responsibility of the seller is to get the goods to the buyer at whatever place they have set as their destination, where they are going to be. Okay? So it's very important that you know whether it is a shipment contract or a destination contract. And for this one, we're looking at this because now we're trying to do both the passage of title and we're going to get to risk of loss. This one, there is a chart on page 448 in my book, if you have the same one that I do, that talks about risk of loss, and this talks about your, again, your FOB shipment, FOB destination, as well as that chart on page 444, which also talks about place of destination, place of shipment. So that's what those are what we're talking about. We're talking about the obligation of the seller. In a shipment contract, it's to deliver it to the carrier. In a destination contract, it's delivery to the buyer. Okay. If it's a shipment contract, title of the goods passes from the seller to the buyer when the seller gets the goods to the carrier. Okay? If it is a destination shipment contract, type of contract, then title passes when the goods are tendered to the buyer at the destination. So tender, tender kind of means offer, but it's tender is when the goods have arrived, they got to the destination, and they're available for the buyer, and the buyer has been told that. The buyer has to be notified. It's nothing in here we want to do in secret. So if the buyer doesn't know that they've arrived at the destination, this isn't going to apply. So the buyer's got to be notified. If it was a problem later, you'd have to be able to prove that too. But the legal part is that they've got to be notified. Okay, so that's when title passes. Okay, in a shipment contract, passes at the carrier. In a destination contract, it passes when there's been tender at the destination and the buyer has been notified. Okay, so at this point, you should now know when the buyer gets ownership, gets title. Okay? All right, so now we need to know, when do they get the risk of loss? All right? And risk of loss, now we're talking about when does the buyer, when are they going to be responsible for what happens to the goods? Okay? So, if it is a risk of loss in a non-shipment, there's nothing in the contract about shipment, then if you have a merchant seller, the risk of loss passes on to the buyer when they get the goods. If the seller is a non-merchant seller, the risk of loss passes when the seller makes the goods available to the buyer. Okay? So a merchant seller, it's when the buyer gets the goods. Non-merchant seller, when they make them available to the buyer. Okay. But let's assume now that we have some kind of shipment contract. Either FOB place of shipment or FOB place of destination. If it is a shipment contract, place of shipment, FOB place of shipment, then the risk of loss passes when the goods are delivered to the carrier at the same time as the passage of title passes. Okay? Now, if it is a contract for FOB place of destination, it's a little bit different. In this case, the risk of loss doesn't pass to the buyer until the carrier tenders the goods at the destination. And tender means that it has arrived at the destination, it's available for the buyer to come and get, and the buyer has been told that they're available for them to come and get. So when that tender has been made at the destination, then the risk of loss passes to the buyer. Okay, now, what if the goods are damaged or destroyed or whatever? All right? If it is before the risk of loss passes, that's why you need to know when the risk of loss happens. If it is before the risk of loss passes, without the fault of either party, I mean, if one person destroys the goods, that's a totally different matter, takes it right out of this. But if it's not the fault of either party, if it is a total loss, and remember we're talking about here before the risk of loss passes from the seller to the buyer. If the goods are identified, damaged or destroyed without the fault of either party, if it is a total loss, the contract is avoided. If it is only a partial loss, then the buyer has the right, after they've inspected the goods, and we talk about inspection of goods and acceptance of goods in, I think it's 2 chapters from now. But exactly what acceptance means and exactly what inspection means, we'll talk about in a little bit. But if the buyer has the option then after inspecting to either avoid the contract or accept the part that's not destroyed or damaged and then get an allowance for the amount that they didn't get. So if 40% of the goods are still okay, they could take the 40% and get an allowance for the 60% that they didn't get. But that's at the option of the buyer. Okay, if the loss, the damage occurs after the risk of loss passes, again, we're still talking neither party's fault here. It's after that it's the buyer's loss. Now, the buyer would have been able to buy insurance at this point. If it's on the carrier may have insurance for this, but the carrier has the right, upon notification to the parties, that they can limit their liability, and then the buyer would be able to purchase additional insurance if they want to, again, remembering back to that chapter. All right, but at that point, it's the buyer's loss. If the risk of loss has passed and they're destroyed or damaged, it's the buyer's problem. The buyer may be able to sue whoever it is that caused the loss, but the seller is going to be out of the picture at that point. Okay, if the goods are not identified, no risk of loss passes to the buyer. We start off with that first one again. The first thing you have to do is identify the goods. If the goods aren't identified, then it's going to be the seller's problem. What happened? Okay, now there are some special situations, and these are returnable transactions, and not every sale of goods allows for a return. So this is what we need to talk about. Okay, you can have a sale on approval, a sale or return, or a consignment sale. These are the three things that we're talking about right now. A sale on approval means that you have sold something to someone. They are maybe now going to use it, test it out, try it out, but it's until they have given their approval, accepted the goods, there's no transfer of title. And the risk of loss stays with the seller, because the buyer is not the owner of the goods at that point. They have not approved. Now, you would have to make absolutely certain that your sale that you're doing this says that it's going to be a sale on approval. If the buyer approves the goods, then it's their problem. But if they don't approve the goods, the seller bears the risk and the expense also of their return. So, there's a lot on the line for a seller in a contract for sale and approval, because the buyer is like the ultimate authority here. If the buyer doesn't approve those goods, seller's got to get them back, seller still has title, and seller still has all the risk of loss. All right, now, a sale or return is different. A sale or return means that it's a completed sale. It's a sale. And the buyer may be able to return those goods, but the title and the risk of loss is with the buyer. And until they are actually able to return them to the goods and the buyer, to the seller, the buyer has the title, the risk of loss, and they have the expense and the risk of returning. They've got to get the goods back to the seller. So in one you have a completed contract, and in the other one you don't. In a sale on approval, it's not completed till there's the approval. In a sale or return, it's a completed sale. And then you deal with how we're going to get it back. All right, a consignment is when somebody, the owner of the goods, the person who has title, gives them to a person who is in the business of doing this usually, a dealer, someone who is going to sell them for the owner, and they take a percentage of this for doing that. This is sometimes what we call a factor, which is a special type of bailee, and they can sell the goods as if they are their own, and then they get money for that. That is treated as a sale or return under Article 2. Okay? A self-service store, most states have the rule that There's no transfer of title until you pay the cashier. So if you take it off the shelf, title doesn't pass in most states at that point. It doesn't pass until you go up and pay for it. Then you have the risk of loss, then you have the title. But when you just take it off the shelf, it's not yours yet. Okay, and auction sales, we've talked about this before, about the with reserve and the without reserve types of auctions. But in an auction sale, each lot is a separate transaction, and if you go to auctions or anything, you'll know it's divided up into lots. Whether it's an online auction or an in-person ground auction, title passes to each lot when the auctioneer brings the hammer down. Now, that could be, online, it could be in person, but the auctioneer is the one who is going to make the determination. And when they say sold and bring that hammer down, that's when everything is going to happen. That is when the person is now going to own it. That's when title passes. Okay? All right. This one will be online on the 13th of August, and that is the date that question number 2 is due. Question number 3 will be a little bit different than the other ones, and if you're looking for a way to get it back to me, I'm going to put instructions on question 3, because some of you might have to take a picture of your answer to question 3 and send it back to me on your phone. Okay, thank you.